Well, welcome back to the Cordell Cordell virtual town hall. Today, we're going to talk about reasons why you may want to consider a modification. It's really the question many guys aren't asking because they just don't know if they're eligible for a modification. They really don't know whether or not what it takes to qualify for a modification. So we thought it would be appropriate today to talk a lot about the modification of child support, spousal support, alimony, custody. So we're going to go through all of those. So I'm Scott Trout, CEO and managing partner of Cordell Cordell, and welcome back. Again, today in the second half or second part of our virtual town hall, we'll be doing a lightning round of questions. Well, you'll have an opportunity to ask questions live on the air to get responses from our panel of Cordell Cordell attorneys. If you want to do that, you can submit that via the Q&A section. If you want us just to read your question, submit that via the chat box. We'll get to that in the second part of our virtual town hall today. As you know, Cordell Cordell is the largest domestic relations firm of its kind in the country, including in the UK. We've been doing this for just about 30 years now. And so also submit your questions to coronavirus.divorce@Cordell Law. If you don't want to address it today, you can send those to that email. I'll be answering those questions via my weekly podcast, where we also talk about spot issues for guys before, during, and after divorce. So today in our podcast, we talked a lot about preparation for your initial consultation, which is huge. Tips, strategies, things you need to do when considering your initial consult. Speaking of initial consults, obviously we're still available and open for your consults. If you have questions, you can do that by checking us out on the web at cordellcordell.com or giving us a call at 866-DADS-LAW. We can set that consultation telephonically, virtually utilizing technology like this, or where appropriate and where we can do it, considering your health and safety in person. But check us out on the web at cordellcordell.com. And lastly, before we introduce our panel of Cordell Cordell attorneys, keep in mind, as I always give this little disclaimer, this is not to get to an attorney-client relationship. And I don't want you to take this as legal advice either. As I've always said, your facts, your circumstances may dictate something different and likely would. And so in order to appropriately advise you, you need to get a consultation with an attorney, and have always suggested you make sure you do so with someone who exclusively practices in family law, just like we do. So before we get into the heart and meat of our topic today, which is modifications, let me introduce to you our panel of Cordell Cordell attorneys from around the country. First, joining us from our Little Rock, Arkansas office, Gianna Messore. Welcome, Gianna.
Thank you, Scott. Thanks for having me today. My name is Gianna Messore. I'm a litigation attorney in Little Rock, Arkansas. I have been with Cordell since 2017. I am also licensed in Rhode Island and Massachusetts, and I have been practicing since 2012.
Thanks, Gianna. Let's go to Raleigh, North Carolina, where we're joined by John Machuca. Welcome, John.
Thank you for having me, Scott. My name is John Machuca, and I work right here in the Raleigh office. I have been with Cordell for the past 5 years. I've been practicing since 2010, and I'm happy to join you all.
Thanks, John. Let's go down south to Florida in Jacksonville. Enrico Zanella. Welcome, Enrico.
Thank you, Scott. Enrico Zanella here from Jacksonville, Florida. I've been practicing exclusively marital and family law since graduation in 2014, all around the state of Florida, and I'm happy to be here today.
Thanks. Let's round out our panel for today. Going back up to New York, a repeat guest, Kimberly Gray. Welcome.
Hi, thanks, Scott. Thanks for having me. I'm Kimberly Gray. I have 17 years of experience. I've been with the firm for 11 of those years, and I'm licensed in New York, Missouri, and Tennessee.
All right, thanks. Let's remind you that if you want to ask your questions live, you can do that via the Q&A section right now. Just let them know you'd like to ask your question live when we get to that in the second part of our virtual town hall. If you have a question, you don't want to read it live, understandably, you can submit that via the chat box. I'll read it for you, and I'll have one of our panel members answer those questions as well. You can also just submit a question at coronavirus.divorce@cordelllaw.com, and I'll address those in my weekly podcast, where we answer the questions of what can I do, what should I do, and what must I do? And I know we're going to get to those three questions as well today when we talk about modification. Before we get to the modification questions and the topics that guys want to know about before, during, and after divorce, let's go to a real quick commercial break, and we'll come right back out of that.
Even in the toughest of times, there are usually opportunities for relief. Many husbands and dads listening now are struggling to stay current on alimony and child support orders. You should know that this crisis may allow you to modify your support obligations, but time is of the essence. If you're a guy needing help right now, not someday when things are back to normal, call us at Cordell Cordell. This is what we do.
All right, welcome back. As we just talked about, we stand ready to meet your needs through the consultation. A lot of what we've been talking about really for the last 16, 17 weeks is seeking advice, seeking information, getting educated, and getting that consultation. Even around the country where we may have some stay-at-home orders, as we know, the countries began to relax those stay-at-home orders. We still have some pockets with some more restrictive areas, but we encourage you to get advice, especially we're going to talk about the situation today. Get a piece of paper, get a pen out, start taking some notes, and start writing down questions. Those are the things you're going to want to bring to your attorney when you talk about in that consultation. So let's talk about modifications and the three things that you may want to consider modifying, whether it be child support, child custody, or spousal support. So I'm going to go to Gianna. Let's talk about life situations, Gianna. Obviously, over the last 16, 17 weeks, things have changed. Life has changed, whether it be jobs, whether it be situations. Obviously, marriages have gone through, and we've had some divorces go through even during the COVID response in 19 or 16 plus weeks. So Gianna, I want to talk about spousal support, what we call alimony or maintenance in certain pockets around the country. And we hear about alimony modification and abatement. And so guys have a lot of questions about what that means. Maybe you can start there and just describe what the difference between a modification of alimony is and abatement of alimony.
Yes, great question, because this does cause a lot of questions for clients when I see them in consultation. So an abatement would simply be a pause of spousal support or alimony during a certain period of time. And then modification would be we're changing your spousal support obligation because there has been a certain change or a life event. So that could be because of the coronavirus, that could be because you have experienced a decrease in your income, you're no longer working, maybe the opposing party is living with someone else now, or simply maybe we now want to terminate the spousal support. That could be another change, and that would be unrelated to asking for an abatement or the modification. So those are three different things that we could be asking for the modification. And if any of those things are going on, we would want to ask for those from the court immediately. It is very important that no matter what is going on in your situation, you want to file your action immediately with the court, because at least in the jurisdiction where I practice, when you file, it will go back to the date of filing. And in some instances, you can ask that the court go back to whenever you have experienced that change. So for example, if we're asking for a modification in spousal support because you are no longer working, we can ask for that to go back to when you experienced your job, even if it's different from when we are filing. The court might not necessarily grant it, but we would want to at least reserve that request because it is discretionary with the court.
And I want to come back to retroactive because it's so applicable to not only maintenance and alimony, but child support, which we'll talk about in a minute with Enrico. But one of the things that's so, I guess, relevant right now, Gianna, every Thursday when we were doing these weekly during the initial stages of COVID, during 12 weeks we're doing it, we were talking about the unemployment numbers that came out on Thursdays. And today, obviously, it's down from its peaks. We're at 1.3 million new claims for unemployment. And so people feel lost and confused. They don't know what to do, where to turn. And obviously they may be under an order for alimony or spousal support. So the question, obviously we touch on it, but what is available to a guy who's either been temporarily laid off or fired, and there's no hopes of returning to a full-time and getting that kind of money that's coming in? I mean, these people that are ones that are eligible to seek a modification, and we've talked about the abatement to kind of stop the bleeding?
It really does depend whether you did agree to the spousal support or if the court ordered it, and whether or not you can modify it depends on that scenario. But we would want to file it immediately regardless of that, and then make that argument. Even if in other words, it would be easier to modify the spousal support if the court ordered it than if you just agreed to the spousal support. But even if you did agree to the spousal support, you could still have some remedies available to you, where we might just ask the court not to enforce the order because it's not fair due to whatever situation may be going on, because you are experiencing this decline in availability of work or something that's going on with coronavirus.
Yeah, doing nothing, obviously, overtime's cut, maybe the order was based on some, regular, recurring, historical overtime, and now you're facing a crunch with trying to pay it. And the question is, it's very similar. I always relate family law to medicine and the doctor-patient relationship and the attorney-client relationship. I mean, obviously we have people at the first sense of a sniffle, or we're not feeling well, they're thinking I've got COVID, I'm going in right away. I want to make a call. And that's what we're really, imploring guys right now. We know at the height, we had 14, 15, 16 million people filing unemployment claims. We know guys don't know what to do. And we're saying, hey, you know what, let's get some information, because as you suggest, the longer you wait, the worse it gets. You may get behind, and there are so many problems, right? If you fall behind in your support and you stop paying it, or you don't pay it, I mean, that spills into contempt, right?
Exactly. I was just going to say that. So then if you aren't paying it, then you could be at risk for the opposing party filing a motion for contempt against you. And then that, of course, opens up the door for these, other litigation and other action. So you want to be more proactive instead of reactive. And we would want to be on the front end and filing your action to modify, or your abatement action, or maybe even a termination action. Or it could be a motion to enforce if you had agreed to the spousal support, where, it might be a little bit more difficult to modify in Arkansas, but again, we could have arguments and remedies available to you in that scenario.
And to kind of round out, I want to come back again full circle to retroactive, because it's so huge when we talk about retroactivity. And that is really, I say, stopping the bleeding, where guys at the beginning of COVID, everyone was afraid to get out, go do anything, or worse, they thought they couldn't do anything, right? And so obviously it depends in state to state, and we'll talk a little bit about it with Enrico and child support. But again, the sooner, and I'm certain during this pandemic, you filed some modifications, it stops it. It gives the authority to the court, right, to go back to the date of filing or service and to say, okay, 9 months from now, let's go back 9 months earlier when you filed, and I'll give you credit for whatever order I enter now, right?
Yes. So the rule here is it goes back to when you file. And then we can also, in some cases, usually when we file too, we can always ask that it go back to whenever you experience that change, as I had mentioned earlier. So if we file on July 9th, but you had lost your job on April 1st, we can put in the motion that we want whatever modification to go back to April 1st. We want to just preserve that. Now, you will get it, if the court grants it, the court will usually go back to July 9th, because that's when you filed it. And I have seen some judges where they'll even go back further to when you experienced your job loss, or whenever that event was, if you did preserve it in your motion. So that's even more of a reason why you want to act quickly, and you want to preserve every argument that you have in that motion.
Yeah. Enrico, I want to go to you and talk a little bit about child support, because typically you will have a guy who has a combination. If he's lost a job but can't afford or alimony, he can't afford the child support. So one goes with the other. It doesn't mean that every guy has both of these, obviously. We see quite a bit with a combination, but maybe from your experience, let's just talk about Florida. Guys are going to say, okay, what does it take? What do I have to prove? Let's just use Florida as an example. Obviously, there's some common elements across the country. What I find, I'm licensed in Missouri, Illinois, and Georgia, and there are very common changes or evidentiary requirements for child support modifications. So what's the law there if a guy's wanting to change his child support because he lost his job?
Thank you, Scott. Well, first I want to touch on the actual alimony, because it really ties into the child support, and then we'll get into the two differences. In Florida, if there's been a temporary change in circumstances, it wouldn't be appropriate right away to file for a modification of the alimony. Rather, you're going to motion the court for abatement, and this abatement will be a temporary change issued by the court that would allow you to either lower or terminate your alimony for a set period of time or until a further order of the court. The reason why it's different from the modification is because in order to modify your alimony, it has to be a permanent change. Most of the situations that we're seeing today, right now, are temporary. And so the motions really can be filed quickly. You can get remedy very quickly in the state of Florida because we're still utilizing Zoom. All of our courts are up and running. So you really can get your remedy for that. Now, child support is altogether different. In the state of Florida, the child support modification is a very small burden. All you have to do is show that your child support has changed by $50 or 15%, whichever is greater. And at that point, you've met that burden that's necessary to get it modified. And the process is much simpler than a divorce process. It's much simpler than a post-modification of alimony or time-sharing process. It's very straightforward. But I'm going to echo the words of my colleague and say you need to file quickly because the court oftentimes will not go back to the date in which you lost your employment, in which your employment was lessened a couple hours each week. It'll go back to the date of filing. And that's very important because waiting 2 months, 3 months could cause your spouse to file for contempt against you. And the judge is going to say, why didn't you file earlier? You knew about this, you failed to pay it, and you should have sought remedy immediately. And that could expose you to fees. That could expose you to having to go to court where this could be a quick and easy resolution where you have to be more proactive in this time. And the judges understand that. And I don't want anybody to think that, well, I don't want to, go into court. I don't want to worry about seeing people. I've had so many consults via Zoom. I've had so many hearings via Zoom. The courthouse is open and we're open. And I think that's something that's important that, time does not, you do not need to wait to go forward on this.
Mm-hmm. I mean, I think we focus a lot, Enrico, on, for example, our clients, guys who are watching right now, on their income going down. But what if their ex-spouse rolling out of COVID gets a far better job and that he believes her income has increased, let's just call it substantially? Does the converse also, work for the guy where he can seek a modification simply because her income's gone up and let's just say he's kept his job?
Absolutely. If his income has stayed pretty steady, maybe a slight increase or decrease, and then his spouse has now had a substantial increase, a pay raise, or a new job that has been $20,000, $30,000 more than what she was originally making, you of course can go forward on that. And your spouse will be required to provide to you mandatory disclosure as to her pay stubs, her financial affidavit, and you would get all of that information in order to change that child support, which as long as there's that 15% or $50 difference, it will allow for the modification to move forward.
Yeah. And Gianna, I want to talk a little bit about parenting plan and modifications. Obviously, we're talking generally about life changes, but before I ask you the question, Gianna, reminder to everybody watching, submit your questions now. If you want to read those and ask them live, you can do that via the Q&A section. If you want us to read the question and ask that of our panel, you can do that via the chat section. Again, first name and list your state so that we can appropriately give that out and see if we can match it up with one of our panel members. But do that now. We're going to get to that in the latter part of our town hall today. And obviously, you can also submit it via coronavirus.divorce@cordelllaw.com. And I'll read those during my weekly podcast. So Gianna, let me talk to you a little bit about parenting plan modifications and life changes. Obviously, rolling out of COVID, we've seen and talked a lot about it when we were doing the news section of our weekly town hall, where we saw parents just really either not taking COVID seriously or denying dad's custody simply out of fear, unfounded fear on COVID, unrelated to our clients' actions or inactions. I mean, obviously, what does it take to modify the parenting plan during this time, regardless of the circumstances that we just talked about?
So this is a wonderful question because we've had so many issues with this during this time. I've had so many clients going through this right now. So I first just want to say that unless there is an order saying otherwise, whatever your decree or order said pre-COVID, it still is in place. Nothing changes because of COVID unless the court issued something saying otherwise. So, because I know there have been a lot of misinformation about that. So if you do want to modify because the other party may not be following procedures with COVID and there may be a concern that there might be an exposure to coronavirus, then we would want to file a modification based on that reason, based on that material change. And we want to do that immediately. Like I think Enrico was saying, you don't want to wait. You want to show the court what the reasons are that are going on in the other household, what your material change is. And just so audience knows, what a material change usually means for the court is we're showing the court that there's been a new event, a new circumstance, something new is going on since your last court order. And that's what we want to be proving to the court. So we'd want to file that in your motion immediately. And always documentation really helps. So we'd want to be showing the court what's going on, what coronavirus precautions that the other household might not be taking, and how that is negatively impacting your child. So are they not putting masks on the child? Are they not following social distance guidelines? Are there, people in the household that might be exposed to coronavirus? Is that on social media? How do we have this information? How can we document it to put that into motion and possibly get that in front of the judge?
Enrico, kind of to wrap up this topic and moving on, but the question really is, we have guys rolling out of COVID where they're looking for other jobs. They've been laid off and they secure it, but it's not in the city. It's not perhaps even in the state in which they've been living in, and they have no choice but to take something, let's just say going from Florida, that they're just going to Mississippi. And what if that happens? Guys watching right now, and he's like, that's me. And I've got to move, and I just moved, and I can't even exercise the court-ordered custody. Does that provide an open door for the guy to go seek a modification to try to change the terms of parenting plan, to try to work with him, because he was really forced to go get a job somewhere in order to make the support payments?
For that situation, there's usually a provision in every parenting plan that's entered in the state of Florida. It's a required provision, whether it's in a paternity time sharing or divorce time sharing. And it states that when either parent relocates more than 50 miles from the residential address that was designated during the final judgment, they have to file for relocation. So it's very important that you file for relocation prior to you moving, because you could actually lose on the relocation on the grounds that you failed to file. And in the state of Florida, you could actually file on a temporary basis and a permanent basis. Temporary meaning that the court will decide the issue temporarily to allow you to move, and on a permanent basis, make a determination whether or not the minor child or children should reside with you to effectuate the parenting plan. I would always tell my clients, you need to speak to your spouse about this first. You need to inform your spouse about it and see if you can come up with something, and then have an attorney review and draft it. But the situation does require court remedy. I can't tell you how many times we've had clients come in and state, I've already moved, and that might have waived that period of relocation. So you really have to make sure that before you do anything, you review your parenting plan, you review those provisions within, and immediately go seek a competent attorney that practices, especially in family law, to determine your next steps, because it could be vital that you do it immediately and that you abide by the court order.
Yeah, it's huge. The relocation is very tricky, and it does go on both sides of the aisle in terms of reporting requirements, depending upon your state. So again, as you suggest, I encourage people to reach out, find an attorney practices exclusively in family law, and they can advise you appropriately. John, up in Raleigh, North Carolina, I want to talk a little bit about behavior. That's another thing to consider, whether or not you should be filing a modification. And, we're talking about an ex-spouse, and their life situation has changed. Maybe their behavior has changed for the worse or the better. They may have a new partner, they may have a new spouse, whomever. They're exposing the child or children, for guys watching, to perhaps people that may not be the most trustworthy, may have some, shaky past. The question really becomes, if a guy's watching and he's learned of some behavior, does that automatically qualify for a modification, or what are they looking for?
Right. It's very important that at early on in your considering a modification, that you do talk with a professional about what is going on with your former spouse. The court's not only going to be looking at the behavior that you're pointing out as potentially troublesome, but they're also going to be looking for a nexus between that troublesome behavior and the best interest of the minor child. So certainly I've been in cases where the other side will say, look, your client engages in some weird, perhaps sexual peccadillos. And I'll say, well, okay, they may do that in their private life, but what connection does that have with the minor child? Now, it's a completely different scenario if the allegation is, well, the former spouse has brought someone into their life that is clearly not capable of watching the minor children, shouldn't be around minor children. That has a clear impact on the best interest of those kids, and a modification, in my opinion, in that instance, is absolutely warranted.
Yeah, I mean, I think that we still use that substantial change in circumstances. That's kind of the magic words you hear quite often from our offices in states around the country, including in the UK. And I guess that's really the question for you is, how much is enough, right? And you're trying to create that nexus. So what is enough?
Right. And I mean, that's the $1 million question, right? And unfortunately, it's an amorphous concept. There really isn't any case law out there which says definitively, okay, if you tick off the following boxes, that's absolutely going to be a substantial change of circumstances, given the judge the authority to modify a permanent custody order. It doesn't work like that.
Mm-hmm.
So what you want to do, again, very early on, talk with your attorney and say, look, this is what is going on with my former spouse. They have someone new in their life, or they have several new individuals in their life. They're moving around constantly. And I have noticed that my child's grades have gone down as a result. That set of scenario, that set of factors absolutely leads to a situation where I think a judge would find that there's been a substantial change in circumstances and would have the authority to modify a custody order. But that's not always the case. And it really comes down to your attorney knowing the judges in your jurisdiction and knowing what each judge would consider to be substantial. It's always very troubling when folks come to talk to us and they list off a couple of things that they find very, very important and very concerning, but us knowing our judges, perhaps having to advise that client, no, we really need to dig a little bit deeper before we file for our modification.
Yeah, I mean, as you say, knowing there's a difference between guys coming in to meet with you, meet with me, saying, hey, I know this is going on, and then proving it, right? I mean, there's all kinds of things we can do to prove it, and that's what they have to focus on after just telling us what they think they know.
Yeah, that's very important. You hit upon a real key facet there. There's a temporal aspect to these issues. And I find that a lot of pro se litigants, so folks that represent themselves and go out there and file a motion immediately upon learning of some new set of circumstances with their former spouse, or perhaps inexperienced attorneys, that they get all jazzed up by this potential of modifying custody, and they run out and file that motion. Well, that isn't always the best thing to do. What you want to do is the moment that you learn of something happening in your former spouse's house, you want to be able to substantiate that with evidence. The moment that you file that motion, it's almost a guarantee that the other side is going to begin to walk back that troubling behavior. They're gonna try to go to court and say, look, none of that happened, or if it happened for a short duration of time. You want to be able to counter that argument. And the only way that you're going to do that is by doing your homework first, making sure that you have your ducks in a row, that you have admissible evidence to prove the things that are going to be alleged against the former spouse.
Yeah. So kind of in a walk away, I like to give guys watching something they can write down and actually an action item, what they must do. So, they're facing the potential, they want to file a change for custody based upon a life situation change. What's really the thing that they should do to prepare for their case?
Yeah, in my jurisdiction, and again, we're here in Raleigh, North Carolina, judges really like to be provided tangible evidence as to what is going on and something that supports your client's contention of a substantial change of circumstances. So whenever I meet with folks, the first thing I tell them to do is begin keeping a custody journal. So anything noteworthy that happens with the other parent, if they are denied custody, if the child mentions something troubling to my client, they immediately jot it down. and they have this journal for a period of months. That is a very, very important tool, not only for us as practitioners. If a client comes to me and gives me their journal and has a great amount of detail in it, boy, I can put together a really strong motion on that basis. There's also an interesting facet of keeping that custody journal, and it's something that I would be able to use at trial to bring to my client and actually have them read into the record. So a journal is actually a hearsay exception. And a lot of folks, even the most loquacious of my clients, when they get up on the stand, they can very well freeze up. And if they do that, I'm able to approach that journal, put it right in front of them and say, okay, tell me about what was going on with your former spouse and this person that they brought into their life. Specifically, look at this specific look at this entry and tell me what happened on that day. That can jog their memory really quickly.
Yeah, it's great advice. And kind of to wrap that part up, are there alternatives? Are there remedies? I've heard of a parent coordinator. Is that something that guys should really ask an attorney whether or not it's available in their region, their state, their locale?
Absolutely, yes. Here in my jurisdiction, parent coordinators, PCs, they are frequently appointed in high conflict custody cases. So there are times when clients will come to me, and in fact, I just had a consultation yesterday with someone who came to me and said, look, I'm having difficulties in co-parenting with my former spouse. They're living with this new individual who, by all accounts, is a nice enough person, but they are just not communicating with me as effectively as they had. When I look at that set of circumstances, I say, is that enough really to qualify for a modification of custody? If I went into court and said, look, judge, the former spouse is just not communicating as nicely with my client, is that going to be a substantive change of circumstances? Probably not. But a remedy that the judge will likely look at is appointing a parent coordinator. And what that person does, and this can either be an attorney or a therapist, is those little issues that arise in the co-parenting relationship, that coordinator will be able to hop in immediately and essentially make a ruling. Okay, if you are not communicating updates, health updates to the other parent, I need you to do that. Otherwise, I'm going to fine you.
Yeah.
This is a great alternative to running off to the court and filing a motion every few months. Your access to a parent coordinator is immediate. So that interim relief is absolutely something to consider when you are talking about modification.
Yeah. Kim, to kind of round up the three ideas and we want guys to be thinking about on a modification, let's just talk about the child and a change of custody and visitation. Is it in their best interest? And I have been asked so many times over the 27 years I've been practicing, whether or not my child or the client's child has any preference rights. Can they testify? Does the judge have to listen to them? Is there a magic age? I'm licensed in Georgia, and Georgia has some specific age issues in terms of their statutes where it's definitive. But the question in New York, or where you're licensed, talk a little bit about that, about whether kids have some say-so.
Sure. I think that's a really great question. My clients are always asking that as well. Basically, a child's preference is always important. It doesn't matter if the child's 5, 8, 16, or 17, but it is still only one of many factors in determining the best interest. Now, along with that, once a child reaches the age of 13 in New York, 13 in Tennessee, 12 in New York, then the preference is given a little more weight. So essentially, the more mature a child is, the more importance the judge is going to place on their preference. This is because younger children are often more easily manipulated by parents, and sometimes older children even. They can be manipulated by things like the promise of new rules at one parent's house or expensive gifts and things like that. The good news is that judges have become really good at detecting when children are being manipulated, and often an attorney for the child or a guardian ad litem will be appointed to help the judge weed through the child's reasoning and why they want to live at a certain parent's house versus the other, and also apply that to the best interest along with the other factors.
Thinking about, just the kids' choices, we know rolling, through this pandemic, we've had distance learning via online, a lot of challenges, not just for the children, for the teachers, but for parents in general. One thing guys may overlook is the kids' performance. We look at their grades. failing, not showing up. Maybe one parent is to blame for that. Is that some of the evidence that guys should be looking for and trying to use, and can they use it in court for a modification?
Absolutely. Teachers, guidance counselors, those are great resources when we are talking about the best interest of the child. I mean, if the child is failing at school and the teacher will say that, you know, the kid is always sleepy when he's coming from mom's house and he falls asleep in class, or he doesn't have his homework done on the days that he came from mom's house, that's a great resource, and we can use that person as a witness. So school, similarly, you know, if a parent is having trouble maintaining a child's specific medical issues, like if a child has asthma and mom has moved in with a guy with who smokes, or, you know, allergies, and he's moved in with a guy with dogs, then, you know, these are all things that lead to a determination of the best interest of the child in the modification in custody.
Yeah, I mean, even you talk about asthma and medical decisions and health needs of the child. I mean, we're talking about COVID. I mean, obviously, one of the things that we've heard for the last 16 weeks is, you know, one parent's not making good choices as it relates to COVID. Maybe that they're going, you know, to the beach, or they're going on vacations, or they're going into hot spots around the country, exposing the child, perhaps putting them at higher risk, not wearing masks where social distancing isn't possible, or just generally putting that child in a situation that guys watching, they don't agree. Obviously, they can use that too, right?
Absolutely. That has come up a lot recently. You know, parents are sometimes not on the same page as far as what is the right way to deal with this COVID thing. And we have to all look at the best interests of the children. And that is something that judges will absolutely factor in.
And one of the big things I think that guys tend to overlook and they get confused with, they want to bring up issues that existed at the time of the divorce that may have, you know, pre-existed the order. I assume that everything that they want to use to try to change the custody has to be since the time of the last order. Is that right?
Yes. Everything that we're using to factor into why we're changing the order has to do with the change in circumstance, and it has to be a change in circumstance since the last court order. So what we're going to do, the first thing we'll do is look at the date of that last court order and talk to you about what has happened since this order. What are the changes? And those are the things that we can use as evidence. Nothing that happened before that were maybe in the underlying matter or something like that.
And the last thing before we get to the lightning round, I want to talk, or maybe two things, is guys here may have been divorced a number of years ago, and their children were young. They may have been infants, you know, they may have been in kindergarten, they may not have been in school. And the parenting plan, you may see around the country what I call infant plans, non-school plans, those things that would they give rise to a potential change just by the passage of time, meaning that if the parenting plan was so restrictive, let's just say an infant plan where there were very few overnights, you know, we're 10 years down the road, 8 years down the road, and now the child's older. Are those the things that may give rise to a modification of custody and visitation?
Yes, as long as that change happened after the last order.
Yeah, because I do see that as a possibility and opportunity, and albeit guys, they tend to have agreements with their spouse that may be altering the plan since then. And I think that that's huge. But keep in mind that they may be having difficulty spending time with the child. And we've talked a little bit about that earlier, about being denied custody. Obviously, I assume the standards are the same if a guy's facing difficulty exercising custody or the plan that was implemented just isn't workable, right?
Yeah, I mean, there are reasons to change the parenting plan. You know, say mom has now taken where she's working different hours and she's having difficulty in taking care of the children the same hours, and dad's available. You know, that's a change in circumstance. If we have a lot of babysitter usage that we didn't have before, and the other parent is right there and ready and willing to take the child, then that's another reason for change. Yeah. So all of these things are factors that the court will consider, that they strongly consider, and they weigh heavily when determining the best interest, because it does really all come down to what is in the best interest of the child at the current time.
Great.
For some dads out there, the coronavirus pandemic has become a pretext to limit access to their children. Other dads have been pushed out of key decisions affecting their children's lives. If you're one of those dads, Cordell Cordell is here for you, as always, but with expanded services. We can meet you in person or by video conference on weekdays, evenings, or weekends. Our goal is to step up our service to meet your needs now.
We're going to get to the lightning round now, and a number of you have submitted questions online. And also, if you have an opportunity, you want to do it now, now is your chance. If you want to ask your question live, you can do that via the Q&A section. If you just want us to read your question, please do that via the chat box. Again, first name, the state, try to allocate that. If we have coverage here with our panel group, we'll get that to the appropriate attorney for that state. Do that right now, and we'll be able to address your questions live. So let's go ahead and go to Ed. I'm going to turn this to you, Gianna. Ed is in Arkansas. We're going to go have Ed read his question.
What should I do if I think my ex is living with a partner but isn't telling me? I don't want to bring my kids into the middle of it and get them to tell on her, but I also feel like the situation is going from bad to worse. I'd like to modify her custody and support agreement if she has 2 incomes in her household now, but I'm not sure what kind of evidence I'd need to back this up. Do you have any advice?
Gianna?
Well, thank you for that question. I think that's a wonderful question. We have a lot of situations like that. So first, we would want to have a discussion about what other information might be out there that we can get without getting the children involved. So are there other family friends or relatives that might be around the opposing party who is seeing her with this new partner who knows that she has this person in her house and is, has a second income in her household? If that's not available, we may want to talk about, the use of private investigators or getting what we call in Arkansas an attorney ad litem. I know it's called different things in different jurisdictions, but that person, they have a lot more freedom to go do house studies, go into the household and see what's going on for themselves. They can talk to the opposing party. They could even talk to her partner. So they can do a lot of investigation, and then they can report to the court as to what's going on and report about the situation, and then make a recommendation about custody and visitation. In regards to the income, I would say that we can do discovery, and then we can get some information about the finances. And discovery is a tool that parties use to share information when getting ready for hearings or mediation, settlement negotiations, things like that. So there's a whole gamut of tools and resources at our disposal that we can use.
Thanks, Gianna. I want to get to Mark's question. He wants to ask live, but before I do that, I'm going to go to read a question from Todd in Missouri. And Kim, I'm going to give this to you, but I think I'll answer it as well, and we'll just see where we both come up with. Todd in Missouri asks, what's the simplest and least costly way to do a dissolution or separation? Assume an amicable, civil, and agreeable relationship with the spouse. So Kim, I'm going to turn to you in just a second, but I'll give you my thoughts. Todd, I've got one right now where a client reached out to me. Wife does not want to hire an attorney. He wants to hire me. We can use one. Obviously, I can only give advice to our client. I cannot give advice to his wife. In my example, Todd, and yours, I couldn't give example or advice to your wife. To me, that is the easiest way, most cost-effective and fastest way, is where I prepared a settlement agreement. Todd, you would provide me with the terms that you think that your wife is agreeable to, as you suggest. We type it up. We type up affidavits. If you have children, we type up the parenting plan. We give this packet to you, and then you review it with your wife. Once she's agreed to it, she has a question, she has to get legal counsel. If not, she can sign it. And we typically, depending upon your location, we can submit that via affidavit. And there's some time periods, 30 plus days have to go by from the date of filing. But it really is a much faster, much easier, with assuming there's no disagreements and no law changes. There's a lot of technical provisions that need to be included in your settlement agreement to protect you. So albeit how enticing it may be to go download a form off the internet, it's not going to have everything you need or require to get it accomplished. So Kim, what are your thoughts for Todd?
I think you said exactly what I was going to say. I agree with you 100%. A settlement agreement that both parties can sign off on is the fastest and easiest way. I would like to reiterate that it is extremely important to have any draft that Scott said, because there are lots of intricacies in that settlement agreement, and the wording needs to be just so. So it actually does what you want it to do. So I think that is extremely important. But I co-sign with everything that Scott said. I think he said the right thing.
And the last thing you need to worry about is your retirement. Obviously, there are so many. We did a podcast on retirement last week or the week before, where we talked about the different areas and different things that need to be done. And there are very specific advantages in the way that retirements are divided. Perhaps if it's non-contributory or it's a pension and there's some surviving spouse rights, you've got to be really careful. And we need to make sure we draft that appropriately to protect your interests. But again, it can be fast, it could be simple and straightforward and cost effective. I'd encourage you to go schedule a consult with an attorney. Obviously, we're available if you want to talk further at 866-DADS-LAW. So let me go turn to Mark from North Carolina. John, I'm going to turn this over to you, and let's hear what Mark, his question is.
My custody schedule only allows me to see my children one weekend every month. This is the result of my job and the amount I used to have to travel. Now, I don't plan to do any kind of travel for work until at least next year, which means I'll be home most of the time. Is it possible for me to try to modify our schedule so I can see my kids more?
John?
Absolutely. Yeah, so that's something that happens fairly often here in my jurisdiction. We have a lot of folks involved in IT that are traveling for their jobs, and then they get a more home-based position and they're able to stay at home. To me, that absolutely qualifies as a substantial change in circumstances, and I have yet to run into a judge that would disagree with that notion. So filing the motion to modify based upon your new work schedule, your new work location, I think you're absolutely going to have the opportunity to modify an order and get more time with your child, which you deserve.
Yeah, absolutely. All right, Enrico, Florida question from Carlius. I'm going to go ahead and read this out loud. A little bit long, we'll recap it for you. Let's see. Carlius says, I'm eligible to retire from my job in Florida, but was not planning to until a rash of health issues happened over the past few years. I currently pay alimony and child support, but have joint custody of my 3 children. If I stop working due to my health issues, what is my burden of proof to have child support and alimony modified? My job is dangerous and very stressful. This will be a 6-digit loss of income. So Enrico, Carlos just wants to know it's going to be a voluntary retirement, but we have some health issues which help when we do a voluntary decrease in income. So wants to know what the burden and the standard of proof is for modification in that situation.
Well, first, let's sit the voluntary retirement. Now, in the state of Florida, there's a Supreme Court case, PIM v. PIM, that allows for you to modify your alimony, whether it be permanent or durational, upon your retirement. And it usually rests upon the retirement age. In this scenario, obviously, we need to know a little bit more details factually to determine whether or not that would be the burden enough in order to modify. Now, if this was a retirement that was voluntary, below what would be considered the age of retirement in the state of Florida, that might not be enough if it's your own willful created inability to work that started this issue. So that's the first one. We'd have to look into to see whether or not you've met that retirement burden. Now, if there's a medical condition, whether it be temporary or permanent, that could certainly be something that triggers that change in circumstances. I think you would probably have the ability to not only petition the court for a modification if it is permanent, but on a temporary basis, if it is something that's urgent, certainly a motion for abatement that would at least stop the bleeding temporarily and allow you to get in front of the court quicker. Now, for child support, the burden is much easier, as we discussed earlier. All it has to be is that 15% or $50. And for alimony, you could abate it through a motion and allow the court to kind of continue its analysis of whether or not this is a permanent situation. So I think that you definitely have remedy, and it really is kind of factually specific, but you at least have a remedy through a motion and possibly a petition to modify the child support and the alimony. The good part is the petition can be involved with both. So in one document, you could petition the court to modify in one count the child support, the second count the alimony, and a lot of the discovery that's mandatory, you're going to 2-for-1 it, which would be a good benefit. But certainly a very fact-specific scenario. And if the drop in income is so significant, it is something that you certainly need to get an attorney to advise you on, and certainly need to move forward on quickly, because even if that hasn't occurred yet and it's going to, I think it's good in this situation, the amount of time, so that when it happens, you file immediately and you have that remedy.
Yeah, Carlos, and kind of going along with what Enrico said, and obviously we're in different states, but there's some commonalities. I represented an orthopedic surgeon who was about the same age as you, Carlos, and he likewise had some back issues, some health issues. Obviously, job is stressful. He had to stand quite a bit. He was paying alimony and child support, so we petitioned the court to terminate the maintenance and to reduce the child support because he needed to retire early because of his health issues. So what we had to do is we couldn't just say, I was stressed and I have, my health isn't good. We had to back it up with proof. We sent him to a doctor. We sent him to other physicians and therapists and psychologists to talk about all of that and produce evidence to suggest why continuing down that path was not in his interest, and it was really going to affect his health long term. So it's something that you need to explore. I encourage you, as Enrico said, to seek out counsel, have that discussion. They can lay out particulars for you, Carlos, that you can do and to kind of position yourself in the best way possible to achieve your goals. So let me go to George, and we'll turn this over to, let's go with Kim. George says, I've been separated for over 6 years. It is not a legal separation, so it doesn't appear there's any court order. Since the separation, I have a heavy financial burden with not being able to find employment. What does a person do in a situation like this, along with all the complications of COVID? And Kim, so kind of what I'm thinking, and I'll chime in a minute, is really, I've had situations where people have been separated for a long period like this for 6 years. There's so many dangers with your spouse. And, if the marriage is broken, time is not as on your side. Time is of the essence to do something, especially even, when you have an unemployment where you may be eligible for alimony. You may be an alimony maintenance candidate. What do you say, Kim?
Yeah, I'd want to know the circumstances that have been going on since the 6 years. I mean, during the 6 years, has he been employed and has he been providing support, or has he just been without support? I think that's really important to know. I think the first thing he needs to do, you need to come in and schedule a consult so we can get a lot more information from you. But I think one of the most important things that you would need to do is get something filed quickly. It's a long time to have gone so far without a court order, and you need one. You need one sooner than later. And like Scott said, you could be eligible for support yourself. If you're struggling paying the bills, and if she's working, then you could be eligible for alimony, and you're losing out on time that you could be receiving that alimony. So I would say that you need to schedule a consult immediately so we can get a lot more information from you and come up with a plan of action.
Yeah, it's just so dangerous to wait. I mean, even if you're accumulating even retirement, albeit you have an unemployment situation, she's still eligible perhaps to continue to those accrued benefits as they continue to go. If she becomes disabled, now you may be on the hook for maintenance or spousal support because you're still married. You're not legally separated. You haven't formulated that legal document. Albeit the marriage is irretrievably broken, this is where you need to take action. So seek an attorney and get some advice. Let's go to Gianna. Gianna, I'm going to ask you this one. This is Rick from Colorado. Divorce is finalized, waiting on the judge to sign an order granting him the right to remove his ex-wife from the home title and order her to vacate the house later this month. I've been told that she may be ordered to vacate, but she could refuse to do so. How is that possible? And what can be done to make sure she vacates? She's already violated several previous orders from the judge. And obviously, there's a lot of things that anybody can violate an order, and that happens all the time, Gianna, as you know. And I think from Rick's perspective, he just wants to know what action he should take, and I have some ideas too. So what do you think?
So if you have a court order saying that she's supposed to vacate the home within a certain period of time, then that court order is effective. So if she's not following the court order, then your recourse would be to file, in my jurisdiction, it would be to file a motion for contempt or a motion to enforce the court order that you have. And essentially what that means is you'd be asking the court to enforce your court order, asking her to vacate. So you'd just be filing a motion to ask the court to do exactly what your current order says, making her leave the home.
Yeah, I wouldn't sit around waiting her or allowing her to continue to violate it. Once you get
Right,
that order,
exactly.
immediately take action. Send it first and foremost, set the stage. Either have your attorney send a demand letter or you send a letter that says, here's the order, you need to vacate on this day. Once she doesn't, immediately file a contempt action and or a motion to enforce, something that your state allows for to at least get her out.
Right.
Worst case, I imagine they could have sheriffs take action. You could do those types of things, but it certainly don't wait around. That's
Exactly. Yeah. And if she has a history of violating these orders, then like you had mentioned, I would definitely, if you still have an attorney or if you don't have an attorney, then I would definitely consult with an attorney about making sure you can get that demand letter out. So you have this plan of action ready to go on that day that she's supposed to leave. So if she doesn't leave, then you're ready to go.
Okay, we have time for about one or two more questions. So I'm going to read this. John, this is a technical one. My wife is now taking or drawing Social Security off of this person's Social Security, albeit he is not yet retired. He's still working. He's also paying maintenance. So she's just started to draw from his benefits. Can he petition to reduce his maintenance by the same amount she's now drawing from his Social Security benefit?
Absolutely. That fits under the category of it couldn't hurt to ask.
Mm-hmm.
Whether or not a judge is going to give you a dollar for dollar credit, who knows? But that's absolutely something that in my eyes and in my experience, a judge would take into consideration when modifying a spousal support obligation, because there's a new stream of income coming to the dependent.
Yeah, certainly. It was income not expected, or at the time. It wasn't factored in at the time of the order.
Right.
As in general maintenance or spousal support, they have to look at the reasonable needs and expenses of the recipient and also the ability to pay. But certainly, if the total income that she's receiving is far higher because she's drawing from your benefits than what the court anticipated, it certainly gives ground to a great motion for consideration. And as John suggested, obviously you need to look at your jurisdiction. There are certainly, for example, in Missouri, where you can get dollar for dollar credit on something like Social Security disability. When those things come off of child support, if the child's receiving drawing some benefits, again, it's money. So the court has to look for income from all sources to determine needs and whether or not they can meet their expenses. So I think it's certainly ripe for an opportunity, right in the wheelhouse of what we've been talking about today. So encourage you to go get counsel. Again, we're available, 866-DADS-LAW if you want to talk to us.
And Scott, I'm sorry, if I could just add something and going back a little bit to Rick's question. Another thing to point out in that situation, if Rick is holding back from hiring an attorney to file that motion for contempt or motion to enforce, he should also consider that with someone that is violating orders so flagrantly, judges will often award attorney's fees. Mm-hmm. So that's holding you back from reaching out and scheduling that consult is the concern over cost. Consider the fact that you're also going to be requesting reimbursement of attorney's fees. So
yeah,
just
absolutely.
throw that out there.
Great point. That is something that's also, if the guys are weighing the cost benefit, they're thinking, why am I going to put money out? And obviously you can get it back. So good point. Thanks, Sean. Last question we have live. I'm going to go to Enrico since it's in Florida. Let's go to Jason to ask a question. That's the last question we have time for.
Thanks for taking my question. I have joint custody with my ex, but I've taken on a lot of parenting time during the last few months. My ex had to continue going into work rather than work from home, then got sick and couldn't see our children while she quarantined in May. Do I have a case for paying less child support or even changing our custody arrangement to fit our current situation? I feel like I deserve a better deal moving forward after pretty much taking on sole custody for most of the year.
Enrico.
That's a great question. The first thing, it's very fact specific, and the question becomes, one, can you modify the child support? Certainly you can. A change in the time sharing schedule is factored into the child support calculations. And so if your overnights have increased significantly, even though the incomes might have stayed the same, that might shift the child support again at that 15% or $50 ratio, which would allow you to temporarily or permanently modify your child support. Now, obviously, if it goes back to the regular schedule, then you might have to go to court if your former wife or spouse is taking you back for that as well. Now, shift that to the parenting issues. On a temporary basis, the court still has jurisdiction over the parenting issues once your final judgment was issued or your parenting plan was ratified and approved by the court. So on a temporary basis during this entire time, you could also get your time sharing schedule shifted temporarily, not permanently, because this might not be a permanent situation, but at least that would allow you to do 2 for 1 and have a set parenting plan on a temporary basis until your spouse gets back into her regular schedule, and a now more, let's say, affordable and equitable child support guidelines based on the true reality of the situation as opposed to what was ordered prior. So you certainly have remedy in court to do that. I wouldn't necessarily say on a permanent basis, but if this continues for over a year and you have that temporary order, well, that might be justification now to show to the court that this is a substantial, significant material change in circumstances that was not contemplated, which would allow for permanent relief.
Thanks, Enrico. Well, that's all the time we have for this virtual town hall this month. Don't forget, you can reach us at 866-DADS-LAW or find us on the web at CordellCordell.com. We're available for telephonic and virtual consults around the country, including the UK, with our solicitors in London. Again, you can find us at call us at 866-DADS-LAW or on the web at CordellCordell.com. If we didn't get to your question, you can also submit it at coronavirus.divorce@CordellLaw.com, coronavirus.divorce@CordellLaw.com. We'll do another virtual town hall next month in August, and until then, stay well.